Jurists for inviting me this afternoon rather. It is evening where I am, or at least getting to be evening where I am. I'm not in Bangladesh at the moment. But thank you very much for inviting me to join as a discussant in this program dealing with virtual courts and advocacy in virtual courts. The question that you have asked is a very pertinent question about cybersecurity. Obviously, cybersecurity is insecurity is inherent in or insecurity is inherent in every system that is used, and using the internet is also at risk. So obviously, as Mr. Afzal has said, there is a risk, and these risks will have to be managed. But there are the real issue here, I think, is the issue of confidentiality, because a lot of information which pass through the wires, through the net, basically is confidential, and confidentiality has to be maintained. So that is something that is a big issue that needs to be addressed. In one of the programs that I was involved in recently, I said that I'm troubled by the fact that courts are using Gmail addresses and not specific addresses for the court itself. The Supreme Court of Bangladesh, in my view, has its own website and should have its own associated email addresses as well. And so if one wants to access the filing section, then we should be able to go to filing. If we wanted to access a particular court or a judge's clerk, we should be able to have this information available. And therefore, if the website is used, then I think the risks probably associated with cyber insecurity will be managed to a certain extent. But using a Gmail address obviously heightens the risks. But as far as, if I may turn to a couple of general points, we have heard the word new normal. Tariq Afzal mentioned it at least 3 times. And so we are actually looking at the new normal and what is going to happen with virtual courts, because they are a reality today. And I have appeared in front of Justice Khurshid Alam Sarkar on several occasions, in several cases, virtually. And the system has worked very well from our experience. I'm sure you'll be able to hear from Justice Khurshid in a moment. But the fact is that although we call them virtual courts, strictly speaking, they are real courts. They are real courts of law, because we have a real judge who is appointed by the Republic to dispense justice on behalf of the Republic. And we have lawyers who are enrolled at the bar and who have rights of audience in the courts to make submissions. So the process, although the hearing takes place virtually, like this webinar is taking place virtually, but the actual business of the court is a real business, because at the end of the day, we do end up with a judgment, which is a real judgment, which affects the lives of one or other of both litigants, I would have thought, in one way or another. So that is important. We're dealing with real courts, not really virtual courts. Hearings are taking place virtually. But the new normal, I think, is going to stay. I think as Tariq Afzal has said, that we expect this to continue. I personally think it will avoid a lot of wastage of court time, because we know that as a matter of fact, as practicing lawyers in Bangladesh, we know that the courts have to deal with processes which are fairly archaic and ancient, and although has stood the test of time, we know that it is very time consuming, like delivering judgment in open court. It takes sometimes 3-4 days. It's a pure waste of time, and the new normal should avoid it. What we should be able to have, and there are many countries in the other jurisdiction where I practice, it's the new normal has been there for some time. Judges just hand down a judgment. The judgment is sent to the lawyers the night before it is due to be delivered. So we receive it by email. And if we have any comments, then we make them. If the judge has got anything wrong, we suggest that there's something factually wrong or something that we haven't said has been put down as has been attributed to us. Then we can make some submissions on that by email, and then the judge corrects it. And in the morning, he just says, this is the document which is handed down. No time is taken, not less than a minute is taken in handing down the judgment. And then from that moment onwards, the judgment becomes effective. So this is something I think we would be able to achieve. I was looking at the speech that was given by Lord Burnet, who is the Lord Chief Justice of England. He gave a speech in Mansion House in the city of London about a month ago. And one of the things that he has said is that and I'm quoting from him, and he was actually quoting another judge, which is this: the idea that lawyers will be required to travel for an hour or two, wait around, and then deploy arguments for half an hour before traveling back has now gone. And I think this is wonderful, because I know that there are many occasions when I came all the way from England to Dhaka to argue a case, and I found that my opponent came along and asked for an adjournment, and the adjournment was given. Irrespective of the fact that I'd taken the trouble of flying over 12 hours, 15 hours, to Dhaka and coming to do this case. So these are the sort of things that will now be possible. We will be able to make representation before the courts from abroad. And also we don't have to come to the court building, because we know that Dhaka, the traffic in Dhaka is quite wild at times, and getting from one place to another is a problem. So if we are able to make submissions virtually, then what the Lord Chief Justice of England has said, that you travel for 2 hours, then just wait around and make arguments for half an hour, and then again make your way back. You will not be wasting time that much. So that is going to be, I think, part of the new normal. Now, whether there's going to be, you have just virtual hearings in one court, like we are having at the moment, or just real hearings, physical hearings in a court in the building, whether that is going to happen, or whether there's going to be a hybrid situation where you have actually maybe a judge sitting in this court and some lawyers being present, but others are not present. Witnesses are not present, because we have experience of taking evidence, particularly in arbitrations. We have practice of taking evidence over video conferencing. And one of the very first ones that I did in my career was over 20 years ago. And we were hearing evidence from witnesses in China, and the tribunal was sitting in London, and I was in London with my instructing solicitors. My clients were Chinese, and we were taking evidence by video conferencing. And we started at, I think, 9 o'clock in the morning, went on till 1, and then started again at 2 o'clock in the afternoon, went on until 5. It was quite late in China by the time we finished, but the line didn't break, and the video played very well, and we were able to get the evidence, the examination of the witnesses, the cross-examination, all done. And a lot of it was being done through interpreters, because a lot of the witnesses were not able to speak the language. So when we talk about advocacy, virtual advocacy, there are things that need to be done. You see, remote advocacy is an art, and this is something that we are not skilled to do at the moment. And I know that the Inns of Court College of Advocacy in England has issued some principles of remote advocacy. So to go on to advocacy, there are certain things that you must do. For instance, like to start off, as a matter of practice, what can be done is that if we were to liaise with all the parties and the judge's clerk in advance, and any documents that we want to present, if those were presented to the judge in advance and he were able to read it, then I think probably things would get much easier, and it would be much better to handle. So we will have to think of new protocols for advocacy in virtual courts, in virtual hearings. The old protocols will go, because the time will, once a case is fixed and everyone is available. And I know that Justice Sarkar is one who is, I think, quite famous for this. So if he has fixed something, he would want the case to be heard, irrespective of difficulties that counsel have. Because in most cases that he hears, he has 2 or 3